revisiting that now that the kids are getting older.
Yeah. Everybody.
Yes.
Board of Zoning Appeals of Westminster is Tuesday, October 3rd, 2023. I guess we'll start with a roll call. I'm Larry Berent, I'm the chair.
Brenda Fraser, board member.
Scott Barrett, vice chair.
Karen Ruff, board attorney.
I'm Debo, the Director of Community Planning and Development.
Okay. Very good. Okay, the statement for the record that at our last board meeting, we had a closed meeting. That was Tuesday, October 3rd, 2023. In accordance with the general provisions Article Section 3-306C2 of the Annotated Code of Maryland. And without objection, it is noted that the minutes of tonight's meeting reflect that City of Westminster Board of Zoning Appeals met in a closed meeting on Tuesday, October 3rd, 2023 at 6:10 p.m. pursuant to the general provisions, Article Section 3-305B7, to consult with counsel to obtain legal advice. Specifically, the Board of Zoning Appeals sought legal advice regarding its responsibilities in the interpretation of the city code and review of the applications and the application of the new board of procedure, as well as a petition to intervene, reopen the record, and for reconsideration filed with the Board of Zoning Appeals. The motion was made by Board Member Fraser, seconded by Board Member Graham, and as minutes will be reflected that we all agreed to the closed meeting. It was 3-0 vote. In attendance also was the Board of Zoning Appeals attorney Karen Ruff. The Board of Zoning Appeals took no official action during the meeting. The closed meeting adjourned at 7 p.m. Okay, and moving on, the agenda, the next would be approval of the meeting summary of October 3rd, 2023. And I think the board members have received the minutes. I have a motion to approve. Second. All in favor, say aye. Aye. Okay. The board also has a couple of decisions to finalize tonight. The first decision is case number 23-05, an application by Tony DiMartino, the applicant and the property owner, requesting approval of a variance for an accessory building use pursuant to Article 20, Special Provisions Section 164-147B, in order to make repairs to a garage at 460 East Green Street, Westminster. The board members had a chance to review this decision?
Yes.
Yes. I'll make a motion to approve. Is there a second? Second. All in favor, say aye.
Aye.
Aye. Okay. One more case on the decisions. Case number 2306 is an application by Nicholas Schisler, the applicant, and Bernice Ecker, the property owner, requesting approval of non-conforming use for the zoning transfer of a non-conforming use to a non-conforming use pursuant to Article 19 non-conformity, Section 164-135B, for an automotive/auto body shop to remain as an automotive auto body shop at 247 East Green Street, Westminster. Your motion? I second. All in favor? Okay, our next action on our board is from the board is a public hearing tonight. This case number 23-03 for the purpose of reconsideration by the board of its decision in case number 23-03, which is an application by Nicholas Thomas, the applicant, and the property owner, requesting approval of special exception to add a home occupation use online sales of firearms and transfer services pursuant to Article 6, R-10,000 residential zone, sections 164-30D at 231 Stacy Lee Drive, Westminster. In opening, actually reopening the hearing, I want to, first of all, for the record, let people know, this is a continuation of an existing hearing, the testimony, and exhibits which were entered at the first hearing are continuing to be a part of the record. And so this is a continuation. And it's a narrow point of, I guess, our purpose is to address the issue of home occupation, its definition, and whether the proposed use meets the definition. More board members agree that that's purpose?
Yes.
And so I'm going to do a synopsis for the record. At this point, I should point out that the applicant has not arrived yet, but the board meeting starts at 6 o'clock, so we come to the meeting, hopefully you will attend. But anyway, this is a matter that was heard by the board on September 5, 2023, and involved an application by Nicholas Thomas for a special exception to operate a home occupation at his residence located at 231 Stacy Lee Drive, Westminster, which is located in the R10,000 residential zone. Excuse me. Of course, I'll do my best. As stated in the applicant's pre-hearing statement, the house occupation will primarily be operated through the mail and will be centered mostly around legal online sales of firearms, and also involve transfer services that are required to be completed in person by purchasers of firearms online. After the hearing on September 5, 2023, the board voted 2-1 to approve the special exception with various conditions. At the board's October 3rd, 2023 meeting, the board was to consider and adopt written decision case number 23-03. However, board on its own motion voted 3-0 to suspend its oral decision in case number 2303 and to reopen the case for the purpose of reconsideration pursuant to the board rules of procedure 18. The ground. Rinse it out. Accordingly, case number 2303 is on tonight's agenda to be reopened for the limited purpose of addressing the issue of the home occupation, its definition, whether the proposed use meets that definition. And again, do the board members agree on this? Since the case is being reopened, the board will hear from anyone who wishes to address the limited issue for which this case has been reconsidered. The record before the board at a September hearing the matter is being supplemented with the information presented to the board this evening, and will assist the board in resolving questions regarding the proposed home occupation. Notice of the reconsideration was advertised in the Carroll County Times on October 17, 2023 and October 24, 2023. The letter was sent to the applicant. Letters were sent to the adjoining property owners as well. By the way of introducing the matter, the applicant applied for a home occupation. The record reflects that property 2231 Stacy Lee Drive, Westminster is zone R10,000 residential zone. A home occupation may be presented or permitted as a special exception using the R-10,000 residential city code section 164-30D. City Code 164.3 defines home occupation as, excuse me, any occupation or profession carried on by a member of the immediate family residing on the premises, provided that, one, there's no commodity sold upon this premises. Two, no person is employed other than a member of the immediate family residing on the premises. Three, no mechanical or electrical equipment is used except such as is permissible for purely domestic or household purposes. The business that the applicant proposes meets the definition of home occupation, then the board has to determine if the request meets the criteria for the granting of a special exception outlined in the city code. The threshold question for the board is whether the proposed use meets the definition of a home occupation. The applicant, in his pre-hearing statement, described the nature of the home occupation as being primarily operated through the mail and, quote, centered mostly around legal online sales of firearms, end quote, and, quote, transfer services, end quote, see Exhibit 3. With respect to the online sales of firearms, the applicant states in his pre-hearing statement that he will have the maximum of 5 firearms in an inventory at a time. The applicant testified before the board that he would purchase the firearms via an online auction site or directly from a distributor. If from an auction site, they would be sent to his house, quote unquote, or quote, discreetly boxed or properly cased, end quote, by way of a delivery service such as UPS or Amazon. The applicant testified that he would be selling long guns, rifles, and shotguns. His purpose is to store the firearms in a locked room. Excuse me, he proposes to store the firearms in a locked room. The applicant would then offer firearms for sale online and meet with customers at the property and site of the house, so the customers could see the firearms and purchase them. No ammunition will be sold from the property or stored on the property in connection with the home occupation. The applicant did acknowledge that he has other firearms on the property that are his own personal firearms for which he has ammunition. When asked by the board how many firearms the applicant would be selling, he stated that he would have to sell 200 to 300 per year to make the business profitable. Regarding the transfer services, the applicant stated in his pre-hearing statement that these services are required for the purchase of the firearms online to complete the purchase. Transfer services would be provided in accordance with the Bureau of Alcohol, Tobacco, and Firearms and Explosives and Maryland State Police rules. The applicant also stated in his pre-hearing statement that he is applying for a special exception, quote, for the purpose of applying for a federal firearms license, end quote, through the Bureau of Alcohol, Tobacco, Firearms, and Explosives. The license would be approved through the Maryland State Police and the City of Westminster Chief of Police as well. See Exhibit 3. Property would be subject to annual inspections by the licensing agency. Excuse me. I will live, hopefully, until the end of this hearing. If the applicant were here, I would invite him to make any additions or suggestions or changes to this opening statement. But and if he does arrive, he will have that opportunity. Again, I'll just restate that this is an extension of the first hearing, and is the limited purpose of certain or determining certain legal issues under the home occupation definition. The board will hear from people in the following order regarding whether the proposed use meets the definition of a home occupation. Staff, the applicant, if he's here, the City of Westminster, any interested member of the public.
why I didn't want to be vice chair, just please.
Well, if I make it through this, I'll turn it over to him to.
Yeah, exactly.
Problem is I ate a potato chip before it.
Yeah.
And I don't have my water, so. I'm good, and I'm good. So at the end of the hearing, the board will close public hearing and deliberate unless the board determines that there is additional information it needs to make its decision. At this time, I would like to swear in all those who wish to testify in case number 23-03. Okay. Do you swear to tell the truth that you're about to give to this board?
I do.
At this time, I would like, I guess the staff to present whatever information they have.
Thank you and good evening. I have nothing more to add from the September 5th staff report. I just want to point out the addition of 2 exhibits. Exhibit 5 would be the notice of tonight's public hearing. And exhibit 6 would be the proof of the ad in the Carroll County Times. And I'm available for any questions.
May I ask,
Yes.
just to clarify, exhibit 4 is the newspaper ad for the first hearing?
The September 5th
Okay.
meeting, yes, exhibit
Yeah.
4 is September 5th, and then these 2 exhibits, well, the notice of public hearing is for tonight's meeting, November
Is 5,
7th is 5, and the,
6 is a letter to the applicant, and 7 would be letter to the,
no, the
Right,
notice of
property
public hearing is for applicant and property owners, with the same notice, same information provided. And then the proof of the ad in the Carroll County Times was tonight's reopening. You're welcome.
Mark, did the applicant indicate by phone call or email that he was aware of this and was in attendance?
I was under the impression he was attending this evening.
I will keep the testimony open in case it does show up. He'll testify whenever he gets here. Okay, again, the applicant would be next on our agenda, and the next presenter would be the City of Westminster. So
Good evening, Chair Burnett, members of the board. I'm Lila Sullivan, I'm the city attorney for the city of Westminster. As you know, we submitted a petition to intervene to address the question of the home occupation. I will I have with me Councilman Don. Let me try that again. I have with me Councilman Dan Hopp, who's going to address you first, and then I will. I have some opinions that need to be addressed.
Good evening. You already know me. My name is Dan Hopp, but for the record, as you all know, I'm a member of the Common Council of Westminster. I am here tonight representing the mayor and my fellow colleagues on council. One of my colleagues is here tonight, Mr. Kavati. My address for these purposes is 45 West Main Street, Westminster, Maryland, 21157. First off, I want to express my appreciation to the board for suspending your non-binding September 5th oral decision in this case, and for agreeing to have this additional public hearing tonight to further consider the merits of the applicant's request for a special exception. The mayor, I, and the rest of the council all have a lot of respect for the board and its members and the importance of the decisions you all make. So thank you for all you do, especially as you all are volunteers. We greatly appreciate your service to the community. As most of you probably remember, I was a member of this very board myself for 11 years. Of course, I had to resign when I was elected to council in 2021. But obviously with my experience on this board, as well as my 7.5 years on the Carroll County Planning and Zoning Commission, I know zoning code issues well and understand the importance of maintaining the consistent application and integrity of one zoning code. Hence why I'm here tonight representing my colleagues who all have concerns regarding this request for a special exception and do not believe it should be granted by this board. Let me highlight a few critical points in this regard. The applicant's property is a residentially zoned property, and its use for any kind of commercial endeavor is inherently meant to be extremely limited. That is the very nature of its zoning. While our code does provide for a home occupation use within this residential zone via the special exception process, the code is very clear that no inventory is to be sold upon the property. Specifically, the code defines a home occupation as, and I quote, any occupation or profession carried on by a member of the immediate family residing on the premises, provided that there is no commodity sold upon the premises. And then there are two other points which the chair already read into the record, so I won't belabor those two points, because I don't think they're relevant to the conversation here. If you notice upon your review of our zoning code, there is no language within the zoning code to provide the board any flexibility to circumvent any of those three requirements for a home occupation. Simply put, if the applicant's home occupation does not meet all three of those conditions, the board should in theory not even go through the special exception criteria. It is totally a moot point. The applicant does not meet the criteria for potential approval as a home occupation. It is very clear to me by watching the previous hearing and reading through the record, and I read through it all, that the applicant is selling inventory. And commodity inventory is another term for commodity. A commodity is inventory. If you look up the definition of a commodity. The applicant is selling inventory via two different manners, actually. One online via the internet, and one via the process he describes as quote, a transfer. Being in sales myself, these words sale and transfer are arguably interchangeable, especially considering the intensity of this particular transfer process. In all reality, this transfer process is in fact a two-part sales process. The initial process begins off-site and then is completed on-site. And the things that are occurring on-site could impact whether the sale is completed or not, from reading the testimony in the record. Such on-site activity is integral to the sales process. It is therefore, in my humble opinion, disingenuous to say such a transfer process does not involve the sale of inventory on-site. Regardless of the quote transfer process, there is still the issue of the sale of inventory online via the internet. Our zoning code makes no distinction as it relates to the internet age. It simply says there shall be no commodity sold upon the premises. Finally, why this case is important is because of the ramifications of any decision this board makes to allow the property to be used in such a manner when our zoning code is clear that such sales of inventory is not to be allowed. Granting the applicant's request for a special exception would open the door to other applicants asking for the same ability to sell inventory, whether that inventory or intensity, whatever that inventory or intensity might be, on their residentially zoned properties. This is highly problematic and also clearly creates a situation that is damaging to our commercially zoned properties and businesses, particularly downtown. If I'm a commercially zoned property and I'm a business and I'm running a business and I have to comply with certain rules in the downtown district or commercial district, and then suddenly I'm allowed to do the same thing on my residentially zoned property and don't necessarily have to meet the same standards or criteria, that is just not fair to our business community, in my humble opinion. If the applicant is interested in pursuing this particular business venture, I welcome him to pursue finding a appropriately zoned property within our city and opening up a shop. It's not like we wouldn't potentially allow such a use. We already have such a shop in downtown Westminster right now. So the applicant is more than welcome to bring more competition to the area if he so desires. It is just that this use on his residentially zoned property is in direct conflict with the provisions of our zoning code. And it would therefore be an error in law and otherwise for this board to grant the applicant's request for a special exception. I thank you for hearing me out tonight. I'll turn it back over to you.
I'm just gonna follow up by saying that as Mr. Hawk was saying, there are two activities that the applicant testified are going on in the property, and one is the transfer that Mr. Councilman Hawk was just addressing, and the gentleman is receiving compensation for merchandise that's passing through the property. And so that is an inherent part of the sale, and you can call it a transfer, but it is a sale from one party to another party, and he's receiving compensation for standing in the middle of that transaction. So I don't think it's accurate to draw a distinction between the transfer and the sale in that context. And then the second part is clearly a prohibited home occupation. It makes no distinction as to the manner in which that inventory is sold, and the applicant admitted that it's maintained on site and is sold via the internet or otherwise. And again, he's getting compensation for turning over an object. And that is the definition of sale. So I will represent that the Common Council as a whole is in support of the position you've heard articulated by Mr. Buck. It has nothing to do with the nature of the quantity it's being sold. It simply is the view of the Common Council that allowing the activities that this applicant has proposed to carry on his residential property does a bit of damage to the integrity of the zoning ordinances.
Okay. Does anyone else care to testify? If not, I will close the discussion here. And I guess the board will now meet and, well, I guess I should take a vote. Is everybody in favor of closing the discussion at this point?
Yes.
Yes, okay. Okay. And I've got to watch our counsel here. She's very particular how I run things here, so.
I can move into deliberations.
Yes, thank you. We're gonna deliberate. So, okay.
I mean, I will start by saying, I think, mistakes were made in assumptions that if something was brought to this board by the city, that it was something that we could look to do an exception for, but I don't believe now and further that the commodity is the commodity. So I don't believe that it's almost a moot point, that I feel like that is not an exception that could even be made. So I think that was part of being brought to the front of here, that it could have an exception. So that's where I failed, I will say, in the first time in understanding that and believing that. I would still be open, applicant's not here, so it doesn't matter, to having conversations about the transfer, not looking at that as a commodity. I would be willing to have those conversations. However, he's not here to have those conversations, so I guess he's out of luck with me on that part too. So.
I also don't think it should have been brought before us. It was a good point from the very beginning. I don't know, does the person have a right to bring a case to the planning commission or the board of zoning appeals if they can't do on a property what the underlying zoning allows, period. I'm not sure that should be brought to light. They can appeal that, the process would be. That being said, I was trying to suspend disbelief and say, okay, guns aside, like, and look at it and not even think, but I did not think this was the right location for something like this in the middle of the greens. But I also didn't see anybody show up in opposition. I don't know if the word even got out to the neighbors, because there was no one here protesting. And I really didn't feel that I read through anything as far as the applicant's presentation or the staff report that would have led me to believe that this wasn't something that could possibly happen. at the premises, and it wasn't until Larry stepped up and basically pulled out, rules and procedures from, I guess some legal dictionary somewhere. It was like, basically said, we can't do this, or we shouldn't. It's kind of the first time I heard that, and basically at the end of the presentation, so it probably should have been tabled. At the very least, and brought up.
I would just, I filed a dissent in this, which I've never done. I've been on the board in, I think, 9 years. I've never filed a dissent. I'll just, rather than going through and repeating everything, I'll just, reinforce it. But in terms of, what's a commodity, the thing I used in the analogy I used in my dissent was the sale of Tupperware. You could take, if somebody could file a special exception and present to the board that they want to sell Tupperware out of their house and from online sources, that they would go online, get the Tupperware, or go to the distributor, get the Tupperware, bring it to, in this case, his house, and then either do Tupperware parties or advertise online, and have people come to his house, buy the tubs and cups and whatever the Tupperware has, and the applicant would be compensated for it, and they would take it home. That being the scenario, even that would not be allowed under that subsection as it appears in the city code. So again, I think as been said here, it's not an issue of the type of commodity, it's an issue of the issues, I guess, as the board members and others have said in this situation. So again, I just harken back to my dissent. I'll try not to cough anymore. And is there any other discussion? How about legal counsel? Do you have any additional thoughts?
Oh, no, I think you've articulated why you decided to reconsider the case. And you have articulated why you thought there was a mistake of law, which was the reason that you had reopened it. So I think you're fine.
Okay. I guess I'll close the board's discussion and ask preferably from one of the other board members.
Motion to deny the request for a at-home occupation sign commodity.
So you're going to move to deny the request for a special exception for home occupation or armed robbery sales of firearms and transfer services.
Correct.
At
Home
231 Stacy Lee Drive.
Yes.
Second. I'll second it. All in favor, say aye.
Aye.
Aye. All opposed?
I'm gonna abstain because the applicants.
It's a 2-0.
And that being the case, the applicant's petition is denied. So moving on, is there any other discussion on this particular item? Is there any other board or any other business before the board at this point from staff or legal counsel or anybody else?
Well, I have written the decision in 2303, approving it. So now I will go back and write the denial and get that to you in the next week or so.
Okay.
Okay.
Will that be like an addendum or we can rewrite the entire decision?
Well, it was presented to you on your agenda the last month for your consideration. However, you tabled it. Wait and see how this played out. So now that will be right. That doesn't matter anymore. If you've taken a different position.
Any other business with the board? Need a motion to adjourn, so seconded,
Second,
all in favor?
I, thank you guys.
Thank you.
And again, apologies, thank you for the water.
You have
Promise to be.
Yeah.